Right from the start, something feels off. This isn't just another probation check-in. This is a repeat failure stacked with missed reports, unpaid fines, and unfinished requirements. And the judge, already familiar with the excuses. You can feel it. The patience is gone. What makes this even more intense is the contrast. Someone with resources, opportunities, yet nothing completed. So the real question becomes, is this confusion or is this deliberate avoidance? Because in this courtroom, the judge is about to find out, and she's not in the mood for games.
All right, Ms. Allen,
Yes,
you're
ma'am.
before the court on State of Georgia versus Kamikawan LaShawn Allen, 2021 CR 04498. Ms. Allen, you were before this court for driving under the influence, stop, or yield sign violation on 25th day of September 2023, sentenced to 12 months on probation. You have 3 months and 21 days remaining, and this is your second hearing. You failed to report on April 14th, May 24th, June 4th, for a revocation hearing. You were released from the hospital and instructed to report after being released. You last reported on January 22nd of 2024. You have completed 0 of 240 hours of community service. You failed to do a clinical evaluation. You failed to do a risk reduction. You failed to provide proof of a victim impact panel. You failed to provide proof of attending AA meetings, and your $2,752.50 in arrears. What's going on?
Your Honor, are you asking Ms. Allen to address it? So,
Whoever can explain to me why Miss Allen's not doing what she's supposed to be doing.
so we were going to stipulate that there is a violation here in all these allegations of violation of probation. She has done some of the things, like I think Mr. Austin here, sorry, would agree with me that she has shown him some proof of some AA meetings. I think that was from February.
Here's where things start to unravel in a very calculated way. The defense tries to soften the situation. Partial compliance, some AA meetings, maybe some community service. But notice the pattern. No proof. And in court, proof is everything. Saying you did something doesn't count unless you can verify it. Legally, probation is built on accountability, and without documentation, it's as if it never happened. What's more interesting is that Miss Allen admits to skipping key programs entirely, like risk reduction and clinical evaluation, which are often the core conditions in DUI cases. So now ask yourself, if you were given multiple chances and still didn't follow through, what should the consequence be?
February of this year, going backwards. So there was some AA meetings. She maintains that she has done a significant portion of the community service hours, although Mr. Austin has informed me that she has not submitted proof, but he may correct me if I'm wrong, that he had some evidence that there was actually some community service being completed at a particular location.
That's great, but I never received the proof. And the young lady who she was doing community service no longer works there, Your Honor.
And other than that, she does admit that she didn't complete the clinical evaluation or the risk reduction program, or complete the victim impact panel.
Okay. Why are you playing with me, Miss Allen?
No,
I remember we had a very long discussion when I sentenced you. Very, very long. And this is your second hearing. We had a long discussion when you came up for the first hearing. Why are you playing with me?
I am not. I promise you, Your Honor, and I apologize if it comes across that way. What I can say is that I've learned over this year that I should not be relying on other people to relay me information, which is what has happened. I pretty much I've not had a stable place to live. My mailing address is my mother's. I bounce between my mother, my father, ex-boyfriend, even a friend's house throughout this past 6 months or 9 months or so. I apologize that I took other people's word for it as far as when I was supposed to report and when I was not, why I was supposed to report and why I was not. And that's to make a very, very, very long story short.
Now we shift into the defendant's explanation. and it's layered with instability, personal struggles, and reliance on others. On one hand, it sounds human, even relatable. Bouncing between homes, confusion about reporting dates, it paints a chaotic picture. But here's the legal reality. Probation doesn't pause for personal instability. The responsibility stays with the individual, no matter the circumstances. And the judge knows this. That's why the phrase, "Why are you playing with me?" hits so hard. It's not just frustration, it's recognition of a pattern. So here's the question. At what point do explanations stop being valid and start sounding like excuses?
Which is the reason why Ms. has half of the information to have proof of. There's no way these people could have seen me in this building all day, every day for 4 straight months and not attest to the fact that I was there doing my community service. Whether that lady was fired or not, she reports to somebody who reports to somebody, and I can give proof to you that I did it. The only 2 things I did not do is the last 2 that he said, the risk reduction and the drunk driving mothers thing. I just hate that. It's so disturbing. I honestly was saving it to last, but everything else I've been doing. AA meetings I do when I'm out. I do it just as a hobby. I love AA, so it's up to you.
What's the recommendation, Mr. Austin?
60 days to serve, ma'am. Credit from August the 9th. After the completion of the 60 days, case will be closed.
Nope. Ms. Allen? Why are you playing with me?
I'm not, I swear I'm not playing. The only thing I have done once again is relied on other people to give me my information, relying on my mother to tell me when my next probation meeting was. There's been times when I've tried to get in contact with him when I wasn't even supposed to report. Drove down here, we live in Decatur. Drove down here just off a whim saying it's been almost a month since the last time I seen him. Let me go down here and see what's going on type of thing.
You working, Miss Allen?
No, ma'am, I'm not at the time. No, I'm not. I'm sorry, I'm not. I didn't have to be honest. Right before I started my probation with you, my husband and I got divorced. I think I shared this with you. We sold a house. I didn't have to work.
This is where the tone completely shifts and the judge locks in. The moment Miss Allen says she didn't have to work, everything changes. Because now the argument about lack of resources collapses instantly. No job, but also no completed classes. No financial hardship, yet thousands in unpaid fees. From a legal standpoint, this is critical because inability is one thing, but failure despite ability is another. And the judge sees that contradiction clearly. It's almost like the defense unintentionally handed the prosecution a stronger argument. So let me ask you, does privilege come with higher expectations in situations like this?
Honestly.
Oh, okay. Well, that's a beautiful thing. 3
But-
months.
I have to now.
3 months. Because for somebody who didn't have to work, she could have afforded those classes. Those classes could have been done. For somebody who has a job, had a car, she could drive to her probation and get all that stuff done. You just told me you drove down here.
No, I said we drove. I
Who is we?
Me, my mother, or my father. I don't drive, man. My license are suspended. I
I'm
don't
clear.
drive at all. Yeah, I don't have a car or drive.
But you had money because you said you didn't have to work, but you could have done the rest of that stuff. And if you live in Decatur, they could have dropped you at a bus stop, or you could have taken the train, or you could have done something close to your house. Ma'am, let's just be clear, because you know how I think. You're an alcoholic.
I know.
And I get that you know it, but when you don't do what I ask you to do, and this is the third time I am asking you to do it. First, when I sentenced you, probably sometime before that, when I talked to you about the charges that you had pending, because your charges pended for a minute. Then I sentenced you the first time, and I explained to you everything I wanted and everything I expected. Then you came up for another hearing, and I explained to you everything I wanted and everything I expected. You playing with me, and I'm done playing. So 3 months.
Yeah.
And Your Honor, would she be get credit for the time since she served since, I guess?
I'll give her credit since date of lockup, but she's gonna do 3 months.
Yes, Your Honor.
Now, Miss Allen, until you're serious about getting your life right, I don't have to be.
And here it is, the breaking point. The judge is no longer negotiating, no longer questioning. She's concluding. This isn't about missed deadlines anymore. It's about public safety. The mention of alcohol, repeated non-compliance, and the risk to others transforms this from a probation issue into something much bigger. You can hear it in her voice. This is about protecting lives, not just punishing behavior. And when she says, "I'm done playing," that's the final signal. The decision has already been made. So think about this. Should the system prioritize giving chances or drawing a hard line when those chances are ignored?
No, you telling me, well, see, I just gonna wait till the last thing because that's disturbing to me. What's disturbing to me is you out there drunk driving and then not doing the things that I asked you to do. The things that are important to me are the things that teach you something. The class, the impact panel, the community service. Those are the important things to me. And you said you didn't have to work. You $2,700 in arrears, so you wasn't paying either.
No, that's not okay. So let me back up a little bit. I may have misspoke. I did a whole DUI probation 12-month period before I met with you. I completed it successfully. I had just completed all of that stuff in another county, Your Honor, in Cobb County. So it was fresh on my, I had just done, and it was, when I say it's disturbing, I didn't mean like it irritates me. I mean like it truly disturbed my spirit to go through all
Well, what truly disturbs my spirit is knowing that I got alcoholics out roaming the streets, driving cars, and putting other people's lives in jeopardy. That's what truly disturbs my spirit. That right there. Oh, every day it'll keep me up at night. So when I give you things to do that I think may make a difference in how you approach things when you get out of jail or when you finish this sentence, and those things aren't done, well, then my spirit is disturbed again. And I don't like for my spirit to be disturbed. I like to sleep. I like to spend the happy time once I am finished with my obligations to the court. But when I have to think about when your petition came up and I looked at it and I said, I wanted more for her, but I expected this. I shouldn't expect you to mess up. That's not how I go into this. When I sentence someone, my hope is that you will do what is necessary to get your life on track, not just to pay your debt to society, but to make your life better. That is what I speak hope to people all the time. But you playing with me, and we're not going to do that. The 3 months, you think about what you're going to do when you get out. You think about how you're going to pursue your sobriety. You think about what you're going to do with the rest of your life. Now, you got your hair braided all nice and cute. You had to pay somebody for that, but you're not paying for your fines and fees. You're not paying for these classes. Now you're about to explain how somebody did that for you just as a favor. No, ma'am.
No. I was
just let it go.
okay.
All right. So you'll serve these 3 months, and once you serve the 3 months with credit since the date of lockup, then this case will be closed. Miss Al, you know above all things that if you mess up again, who you coming to see?
I'm coming to see you, Your Honor.
Do you want to come see me again, Miss Allen?
No, ma'am.
All right, then. I didn't think so.
Judge, you were done with this.
Yeah, you can go back, Miss Allen. Thank you.
Thank you.
This case ultimately comes down to one powerful theme: responsibility. Miss Allen was given multiple opportunities, clear instructions, repeated warnings, and structured programs designed to help her improve. But instead of progress, the court saw inconsistency, missed obligations, and unmet expectations. From the judge's perspective, this wasn't just about punishment. It was about preventing future harm, especially in a case involving DUI concerns. That's why the final sentence, 3, Months wasn't just a penalty, it was a reset. A forced pause to reflect, recalibrate, and hopefully return with a different mindset. Because in the end, the courtroom isn't just about consequences, it's about accountability and change. And when that change doesn't happen voluntarily, the system steps in. If you found this case as intense as we did, hit like, share your thoughts in the comments, and subscribe for more courtroom breakdowns.